The Justice Department says an interdict application by Xulu and partners fails to meet the requirements for urgency. The law firm has lodged an application seeking to stop the president from appointing the next National Prosecuting Authority head. It follows interviews earlier this month to replace Shamila Batoy, whose term ends next month. The department says it will oppose the application, arguing that it is premature. It adds that the president is still considering the advisory panel's report. The law firm claims its objections to former independent directorate head Hermonia Cronje's candidacy wasn't properly considered. All right, for more now, we are joined by the law firm's director, Barnabas Xulu. Xulu, thank you so much for your time and for joining us this evening. Maybe just elaborate for us on the specific legal grounds upon which your firm has based this particular application to interdict the appointment of the NDPP.
Good evening, Katlego, and good evening to the listeners. The case is all about the defective process that took place when the panel or the advisory panel set. And we are saying the integrity of that process, the transparency and the fairness of that process was supposed to be something that is uppermost to the panel. So because there are uncontroversial facts which we can establish that clearly the panel did not observe the transparency, the fairness and integrity, that process then falls to be tainted. And we have a right as the objectors who have made an objection to object to the validity or the fairness or the transparency of this process.
Maybe just unpack that for us in terms of what you think are the key legal principles that underpin the requirement that you speak of transparency and fairness, especially when it comes to public appointments such as this one.
So the most important thing is that everyone needs to understand that the NDPP its foundation is from the Constitution, Section 179 of the Constitution, which makes it clear that it has to be independent, talks about the independency, where when it makes its decisions, it has to be fair, it has to be making those decisions without fear, favor, or prejudice. This includes when it comes to the appointment process itself. In this case, we are aware that it is the president that has got the power to appoint the NDPP. But that appointment, what has happened is that he has opened up to the public to make observations, not necessarily observations, but to make objections to that process if there is anyone who's having any kind of objection. And in this case, our firm has an objection that was not considered fairly and was not being considered properly to give the candidate concerned an opportunity to respond like other candidates were compelled to answer on 2 occasions in writing and also to answer by attending to public scrutiny when the members of the panel were supposed to be asking and hear the response. And in that way, we were also going to be able to hear that response, what was the nature of the response.
And I believe this is in relation to Advocate Cronje. What exactly was it that you wanted asked so that you could get that response from the advocate?
Okay, so our objection is that Advocate Cronje, and this is supported by evidence, the evidence is in the form of emails and other documents. Our objection consists of 99 pages. I will not be able to outline everything here. It's a bit of a long story, but
right.
If you read our objection, it contains an email that she was exchanging in obtaining the confidential information which was in possession of the NPA. and in a matter that was not assigned to her, in a matter that has got nothing to do with the ID for that matter. But she accessed that confidential information, and that information ended up being manipulated and distorted, which has led to a long-running matter which has not been resolved to date. So we have the evidence, how she obtained that information, from who, how the information actually ended up getting the information, ended up getting to the wrong hands, in other words. That's basically what we're saying. And we were providing that information over and above. We're also able to provide the memorandum that did the assessment of the work that she's complaining about, which made it clear that there is nothing wrong. There is nothing wrong that has been committed by this firm of attorneys that has undertaken this work. And at all material times, when this work was being performed, it was above board.
So, I mean, as a firm, you've also just said that there's alleged bias and procedural irregularities that you identified within this process. Maybe just talk to us about that legal significance that you outlined there.
Yeah, that is very correct. So the panel invited the objectors, and the process that was supposed to be involved in that objection was, one, they were supposed to be given to the candidates concerned. Once given, they were supposed to respond to it. Once responded to it, then also be subjected to the questioning by members of the panel. And in this case, Advocate Cronje said so herself, that she has never seen the objection. All the other candidates that were participating have received their objections. Two, after she has not received the objection, she was allowed to carry on maligning the firm and myself. Instead of responding to the objection, the purpose of delivering the objection was for her to respond accordingly like all others. Now, that has at least given an impression that she's being favored. Others had to make answers publicly, but she was somehow going to make an answer, but not in a similar manner like the other candidates have done.
So the Department of Justice has responded, and they've said that they intend to file a notice to oppose on the basis that your application does not meet the requirements for urgency and is quite premature. What's your response to that?
Well, without necessarily litigating over the live TV, but all that I can tell you is that it is common cause that at the end of next month, the president will have to announce the replacement to Shamila Patoy. And that announcement is imminent, because otherwise that position is going to become vacant. Unless the president were to give us an undertaking that, look here, I'm not going to make a decision in January, I will make my decision probably next year, then there will be no agency. But as matters stand, we don't have that undertaking.
Yeah. What would you say are the measures that really need to be put in place to prevent bias and ensure fairness in high-stakes appointments such as that of the NDPP? I mean, you also speak that this is a decision that the president needs to announce by the end of next month, when the current NDPP ends her term.
Look, the nice thing about our country is that we've got a constitution, and constitution provides a guide. Like in this case, the presidency came up with this kind of approach in order to show that I have opened this process to the public to participate. Even though this process is not contained in any legislation, either in the Constitution or in the National Direct Public Prosecution Act itself, it is there. It is the one that enhances the fairness, the integrity of the process. So we have to be guided by the principles of fairness, by the principles of integrity. Now, in this case, for instance, it is very clear that, I mean, we could hear the minister who was sharing saying that we don't want to be seen as if we are doing a favor for you, something to that effect, by making you not to answer. You have to answer, but not now, because we don't want to put you under pressure. But every other candidate without fail, when there were objections, they had to attend to them. That's why we became the only objectors that are raising this complaint, because our complaint was not properly, in a fair manner, in a transparent manner, received the attention that it required to receive, which is passing the legal muster or the constitutional test of fairness and integrity.
And why do you think that is so? Why do you think that it is that your application, in terms of that objection, was formally submitted beforehand? Why do you think it was ignored?
You know, it begs one to wonder. I don't have what you call knowledge of what were the private conversations, if there were any. I've only seen, which is proven, that she said, I did not receive this complaint. They confirmed that, yes, in fact, we did not give you. But also, if you look at, if you follow the interview, you can see that even the other members of the panel, they looked shocked, as if they did not receive the same complaint like others. It seems as if it was only the chairperson and one panel member who had access and at least the benefit of understanding what is contained in the objection. The candidate herself did not have, she has not seen, and I've got no reason to doubt that she was not telling the truth when she said she's hearing this for the first time and she has not seen what is the complaint about. She seems shocked.
So if your application succeeds, what changes do you foresee in the appointment process for similar positions in the future?
Well, we're anticipating that there should be integrity. I mean, integrity can be observed even by a layperson. You don't have to be a lawyer or an expert in whatever. Where, for instance, they are clearing things like this which have happened, where someone can tell the panel that she's not part of the NPA, but she could easily tell them that I've got an intel, what is going to happen, who's going to leave, who's not going to leave. And they didn't take her to task. That alone was tainting. But that's not why we're in court at this moment. At this moment, we're in court in terms of correcting this process, ensuring that this process is undertaken in a fairly manner, independent manner, as commanded by Section 179 of the Constitution, because that is where we can borrow this spirit.
Well, certainly. Xulu, thank you so much for explaining and unpacking what this objection is about. That is the law firm's director, Barnabas Xulu of Xulu and Partners. Now, when we return, we speak